This talk is about financial privacy and whether or not it actually really is dead. Companies all over the world have many features in common. So what do you do with this company which has no shares or share capital? Good afternoon, delegates and ladies and gentlemen. This talk is about financial privacy and whether or not it actually really is dead. And we take the view that it's not dead, it's just in a coma. And this talk is about how to get financial privacy out of its coma so that you can still have 100% financial privacy. We all know what happened with the FATCA, which came in 10 years ago. And we saw how the United States turned the banks into tax collectors for Uncle Sam. A lot of people thought this was a sledgehammer to crack a nut. And many US citizens now have terrible difficulties with owning a bank account. Now, the EU saw this FATCA model and they rather liked it. So they brought out their own version, the Common Reporting Standard, CRS, otherwise known as Automatic Exchange of Information. Now, for many, this was a massive shock. And the shockwave it created has resulted in the suffocation of the offshore planning industry almost overnight. It seems that governments have won the battle and have succeeded in putting the offshore or low tax industry out of business, or as I prefer to say, almost out of business, as you'll discover in this talk. Banks used to be our friends, but now have become our enemies. And we put the old poor relationship manager in the top banks as they don't have jobs anymore. These have been taken over by their compliance departments, or BPUs, as I prefer to call them, business prevention units. Now, if you think of the art of self-defense, the most important principle is to use your opponent's strength against him. What do I mean by that? Well, what I mean is, in a nutshell, you get the banks to report what you want them to report, not what they think they should report. And there's never present feature in limited companies. Companies all over the world have many features in common. A feature which is obvious. 99% of all companies have this feature. And what is it? You take a standard UK company formed online for a few pounds, incorporated in less than 2 hours. What are its main features? Well, it must have a registered office. It must have directors, one of whom must be a natural person. It will need to file accounts and file annual returns and an annual audit. The one thing practically 99% of UK companies have, from small family companies to multinationals, is what? You all know the answer. It's under your nose. They're all limited by shares. Now, a bit of history here, which is quite interesting. In 1900, the UK, England, had become the largest stock market in the world and was the leading industrial nation. Remarkably, freedom to incorporate as a limited liability company had been available since 1855, but in uncertain and experimental format. Even more remarkable was the fact that England had undergone the Industrial Revolution without freedom of incorporation, with a legal framework which restricted the development of business organization. Indeed, most of the business enterprise which formed the backbone of the Industrial Revolution were sole traders, partnerships, or unincorporated companies. Unincorporated companies had existed in the UK for hundreds of years before 1855. Then came the joint stock company in the landmark case of Salomon and Salomon, which finally decided that a company has separate legal personality, it has limited liability for its members, management is delegated, and you have investor ownership. And what else? Transferable stock or shares. Now, the problem with owning shares is that they are personal property and they're subject to being taxed. When you own a share in a company, you own an asset, and the owner of shares can be taxed quite heavily when he sells that asset or those shares at a profit. He can also be taxed on any dividends that the shares generate, unless, of course, the company is incorporated in a zero tax jurisdiction. And it used to be a simple idea to use an IBC in an offshore jurisdiction, a cheap and cheerful way to hold wealth, almost anonymously, but that is no longer an option. What's even worse for the owners of shares and their next of kin is that upon their death, tax will be due on the value of the shares bequeathed to their next of kin. With shares, there are obvious pitfalls. There's registration and records, transfers are recorded, and there is taxation. As I say, taxation because you own an asset and which is personal property. The holy grail of tax planning has been to separate the ownership of assets, in this case, specifically shares in a valuable company, from the true owner, that is the beneficial owner, so he could remain confidential and perfectly legitimately remain untaxed because he didn't legally own the shares. Hence the use of trusts. The last talk I gave here was a brief history of the trust, which everybody needs to be reminded of where we have got to with trusts today. We saw during the second half of the 20th century, the functions and forms of settlements had changed beyond all recognition and to a radical degree. Trusts were no longer involved with landed estates. They had moved into new ground with business and commercial enterprises. In the UK, the introduction of capital gains tax in 1965 made the use of trusts in a modern commercial environment even more appropriate. But there was this inexorable change in the nature of trusts as businesses and commercial enterprises became the dominant client base. And now that trusts have become established, indeed well established, entrenched in the commercial world, owners were very happy so far because they had protected their wealth for the benefit of future generations. But commercial owners were unhappy that by doing this, they had essentially lost control of their wealth. They liked the protections and tax advantages a trust could provide, but they disliked the loss of effective ownership and, worse, control. So they then began a series of inventive statutory amendments to trusts in offshore jurisdictions, which have been consistent attempts to give greater control to the settlor or the former owner. This began in 1989 in Bermuda, where for the first time we see a wide range, of about 9 in all, of reserved powers granted to the settlor. This was followed in 1997 in the Cayman Islands, where star trusts were introduced. Here, the settlor was empowered to appoint an enforcer who can enforce the terms of the trust, and in addition, the rights of beneficiaries to take enforcement action against the trustee were eliminated. Theoretically, and if appropriately arranged, this gave control to the settlor. Then in 2004, we saw the introduction of vista trusts in the BVI, whereby a settlor or his appointee could have control of the assets within a trust's underlying company, thereby giving the settlor de facto real control of the investments and assets without any trustee involvement. Now, what all these provisions effectively have done since 1969 is to progressively devalue the office of the trustee. And they now have created acute problems for the courts of chancery in terms of dispute resolution. Many mature trust jurisdictions might not even recognize these modern offshore trusts of today, and they might see them, for example, as shams or unconstituted trusts, either way, a disaster for the settlor. So, think outside the box. What do I mean? Well, coming back to companies, we've seen that companies with shares are simply targets of revenue authorities. This is because there is a paper trail demonstrating share ownership. And it's no use trying to use a trust today because the banks insist on knowing the identity of the beneficiaries, even if they have received nothing. So trusts, as I explained last time and briefly above, are holed below the waterline. They're no longer fit for tax planning purposes. And foundations are treated in exactly the same way. So the world of trusts are no longer reliable in terms of tax planning. And in terms of financial privacy, again, that's gone. So let's think outside the box. If shares are the core issue about ownership, control, and tax, supposing there were no shares, can you have a limited company with no share capital? Can such a company exist? Well, yes, it can. It's the company limited by guarantee. The most plausible origin of the company limited by guarantee, we think, stems from the fire insurance, which came into existence after the Great Fire of London in 1666. For this type of tragedy to occur at a time when England businesses communities were beginning to flourish was great devastation of utmost significance. The Great Fire may have been the catalyst that drove individuals to find better ways of insuring themselves in the future, should another similar tragedy occur. Individuals had to protect their future economic interests, and the emergence of a company that allowed individuals the ability to conduct business as needed while providing them with the limited liability necessary to protect against future damages may well have been the foundation of the company limited by guarantee. Now, today, these companies are usually non-profit entities and mostly charitable in many cases and used by friendly societies and small clubs. Common uses of companies limited by guarantees include clubs, membership organizations, student union, residential property management companies, sports associations, other social enterprises, non-governmental organizations, and actually one political party in the UK. The England and Wales Cricket Board, I follow cricket, are also companies limited by guarantee. Australia also has companies limited by guarantee, as do almost all Commonwealth countries. And to become a member of a company that has no share capital, to become a member of a company limited by guarantee, means that the person signs a guarantee for a sum certain that it will pay to the liquidator in the event the company is wound up. He then becomes a member of the company. Whereas in a company limited by shares, he would become a shareholder by purchasing shares. Now, as there are no shares, he is simply a member. And the great thing about guarantee companies is that members can come and go. They arrive, they sign a guarantee document, and they become members, they go on the register of members. Then if they want to leave, they just tell the directors they don't want to be a member any longer. The guarantee is retired or extinguished, and they're no longer a member. So it's very easy for members to come and go and join such a type of company. Now, if you take a standard UK company, guarantee company, think about this. Supposing you didn't appoint the client or a person who is to be a beneficiary, supposing you didn't appoint him as a member of a guarantee company. For example, you could appoint a nominee, but that's no good because you can't hide behind nominees any longer, as the banks will want to know who the BO is. So what do you do with this company which has no shares or share capital? So there we have our UK guarantee company, NewCo. And what does it need? Well, it needs a board of directors who you want to make sole controlling persons and ultimately beneficial owners. And they will have the sole management rights to manage the company. No one else, just the board of directors, which is pretty usual. But then on the left-hand side, which is the money or ownership side, if you like, we have a guarantor member. He's got no management rights, and that's critical. But he does have sole distribution rights. So in this structure, on the right-hand side, you've got board of directors who have no distribution rights, whereas on the left-hand side, you have a guarantor member who has no management rights, but sole distribution rights. But of course, if the guarantor member is the client, he's immediately visible, and you don't want that. You're trying to actually arrange this guarantee company so that he's not appointed as a member. So who do you make the guarantor member? Well, here is where such a company is so flexible, because you could make the guarantor member a trust. You could make it a purpose trust. You could make it another company, a nominee company even, which could make the board of directors the sole controlling persons. Once you get to that stage where the board of directors are the sole controlling persons, they become the beneficial owners of the company. So you need probably a special director included on the board who would act as a protector effectively. But if you notice the structure, and I have to tell you, a lot of people are quite familiar with this structure at the moment. And in baseball terms, you want to get to base 4, which is where the full structure works, where the client becomes anonymous. Here you're at base 2. And to get to base 3 and base 4, you require the UK company, the memorandum and articles of association, to be meticulously drafted in such a way that the board of directors have sole control, and there is no room for anybody else to have control, no powers of attorney, nothing like that whatsoever, no nominee arrangements. And so that will make the board of directors the sole controlling persons and beneficial owners. Now, you look at that diagram and you say, well, where is the client? Well, that is the whole point of structuring a guarantee company like this. The client is nowhere. However, he is linked to the company by means of a special deed of option. This deed of option, which he keeps in his safe, permits him, the client, to become the beneficial owner of the company if he applies to the board of directors under the deed of option. So the deed of option is linked to the client. It's a deed granted by the board to the client. It's a confidential document, and it gives the client the right, if he ever wanted to, be the beneficial owner of the company. But then, of course, he becomes disclosed. So usually the clients never exercise that option. Now, of course, the special deed of option is the second document that is required in this kind of structure, that has to be drafted with meticulous care. And there is absolutely no room for error, because if you get the memorandum and articles wrong, and you get the special deed of option wrong in its drafting, this whole structure falls down and it won't work. So you need special drafting, specialist drafting, not only of the memorandum and articles of association, but you need special meticulous drafting for the special deed of option. Once you have the company at base 4, where the client appears nowhere and he's somewhere in the ether, you will find that the client has no directorship, he's got no shareholding because it's a company limited by guarantee, he has no interest, he's got no management rights, and he's got no power to enjoy the assets or income of the company. Power to enjoy is an expression used in trust law, which effectively gives a beneficiary a disclosable interest in the trust. But here, by analogy, in a company like this, there is no right, no power to enjoy the assets or income. Further, he has no right to secure income on a winding up. Therefore, you end up with a situation where there are no reporting requirements. And as far as the client is concerned, now, as far as reporting is concerned, the board of directors are the people that are reported by the banks. And here you've got to be very careful with your jurisdictions. You have to choose a jurisdiction that is either territorial tax or source taxation, and also maybe a jurisdiction which is only remittance basis. But once you have it at base 4, the client is effectively anonymous, and he's effectively invisible. This structure not only provides incredible confidentiality, but it eliminates inheritance and asset protection issues, because obviously if he owns nothing in the company, he can't be sued. And in terms of inheritance, that's very easily dealt with, because say he is married, he will, on his death, his wife will step into his shoes under the special deed of option. So you have also an effective living will. So that really concludes this talk on how you get confidentiality out of its coma. You can still have complete financial privacy. There are ways to achieve it, okay? It's just knowing how to do it and having the expertise to draft certain documents in such a way so a structure like this works. As for ourselves, we look after high net worth individuals and ultras only. We have been doing for 20 years, And we've been using these structures for 20 years. We've never had a problem with them at all. And in fact, clients prefer them to trusts because they're easier to administer, they are easier to control, and they don't cost a fortune in trustee fees because you have capped fees for the board of directors.
Jonathan, thank you very much for your very interesting and detailed information and historical background.
To form a company like that, we charge US dollars 15,000 or 0.25%, whichever is greater, and annually to repeat it's US dollars 10,000 and or 0.25%, whichever is greater. That's what people usually want to know after such a presentation.
It's very important, exactly, the expenses, which are quite reasonable for this case, I find.
Yes.
Yeah, great, great.